Hello everyone, a very good evening. Welcome to Oliveboard. This is the CAIIB Foundation series for the June 2025 exam, in which we are covering the BRBL paper, all the units module wise, and today we have the part 2 of our unit 27, the Partnership Act of 1872. We have already discussed the relations of partners to one another, the relations of partners to the third party, the definition, meaning of a limited liability partnership, everything we have covered. Now we will talk about what if or can minors be admitted to the benefit of a partnership or not? What will be the legal position of the minors after they attain the majority? Regarding the retirement of a partner, the insolvency, all of these things we are going to cover. All right. So we know under the Indian Contract Act that 18 of the 1872 that minor is not competent to enter into a contract, right? So he is not eligible to enter into a contract of partnership as well. However, a person who is a minor cannot be a partner in a firm, but with the consent of all the partners, he may be admitted to the benefits of the partnership. They cannot be made liability, and under no circumstances can the minor be made liable for any liabilities of the firm. They cannot be personally liable for the acts of the firm, except to the extent of such minors share in the partnership. So the minor can have a share in the property and the profits of the firm as agreed upon the partners, and the minor can also have access to the accounts of the firm. However, only the minor's share is liable for the acts of the firm, but the minor is not personally liable for the acts of the firm and the liabilities arising therefrom. All right. Again, the minor may or may not take a legal action against the partners for the payment of the share of the property or the profits of the firm, except when ending his connection with the firm. All right. Now, what is the legal position of the minor after they attain the majority age? So, at any time within 6 months of his attaining the age of majority or of his obtaining the knowledge that he has been admitted to the benefits of the partnership, the minor partner who has attained majority may give a public notice informing whether he has elected to become a partner or not. Whether after attaining the age of majority they want to become a partner or not. And this notice determines his position as regards the firm. However, if he fails to give such notice, then he shall become a partner in the firm on the expiry of the said 6 months. So you need to remember that within 6 months they need to make a public notice, or automatically they will become a partner and they will now be liable, right? So, where such person becomes a partner, either because he was elected to do so or because he failed to take a decision and 6 months have elapsed, then his rights and liabilities they continue up to the date on which he becomes a partner. Now they will also become personally liable to the third parties and the acts of the firm, right? His share of the property and profits of the firm shall be the share to which he was entitled as a minor. All right. Now, if we talk about the retirement of a partner, the partner can retire with the consent of all the other partners in accordance with an express agreement by the partners, or where the partnership is at will, they can retire by giving notice in writing to all the other partners of his intention to retire. If they want to retire, they can follow any of these three steps. The retiring partner as well as the other partners now will be liable to the third parties for any act that were done by them before the retirement, right? Then A partner can also be expelled from the firm by any majority of the partners in good faith. All right. If we, let's say, talk about the insolvency of the partner, if partner of a firm is adjudicated as an insolvent, she or he ceases to be a partner from the date on which the order of the adjudication is made, on the date itself. Right? So the partner now ceases to be a partner. That person is no more a partner when they are adjudicated as an insolvent. This order of adjudication may or may not dissolve the firm. It is not necessary that the insolvency of a partner dissolves the firm. If, let's say, the firm is not dissolved pursuant to the contract upon the adjudication of the partner, the estate of a partner is not liable for any act of the firm, and the firm is not liable for any act of the insolvent that is done after the date on which the adjudication order is made. After the date, the firm will not be liable for their act, any act which is done by the partner declared insolvent. All right. Next, if we are talking about the dissolution of the firm, a partnership firm can be dissolved, right? But here we need to understand the difference between the dissolution of a firm and the dissolution of a partnership. Both of these things are very different, right? So where there is a dissolution of the firm, there would be a termination of the firm and the end of business relationship among all the partners. Whereas when there's a dissolution of the partnership, there is only a change in the business relationship among the partners and the firm continues to run. When we are only dissolving the partnership, the firm will still continue. It will not stop operating. But when we are dissolving the firm, it will just end the business of the relationship among the partners. All right. Thus, there is a distinction between the dissolution of a firm and we will say the dissolution of a partnership, or it can be also termed as a reconstitution. Reconstitution of the partnership. All right. So, dissolution of the firm means there's a breakdown of the relationship between all the partners in the firm. Right. Now, the dissolution can be a compulsory dissolution if all the partners are adjudicated insolvent. All the partners have been adjudicated insolvent except one. Then the firm is dissolved, or by the happening of any event which makes it unlawful for the business itself to be carried out. If the law has declared any business unlawful, then also the firm will be compulsorily dissolved. However, if I say that business or a firm ABC was involved in three businesses, a car business, a jewelry business, as well as they were involved in the business of, let's say, kitchen utensils. And this kitchen utensils business has been terminated. Do we require to shut down the car and the jewelry business also? So, no. Dissolution, if let's say the partnership firm is carrying on more than one separate business, the illegality of one or more does not cause the dissolution of the firm. The firm can continue to carry on all its lawful adventures and undertakings. All right. Then this was the compulsory dissolution. Other reasons can also be there, like the certain contingencies. If the partnership is constituted for a fixed term, then by the expiry of that term, or for carrying out one or some particular undertakings, once the task is done, it can be dissolved. If there is a death of the partner, and by the adjudication of a partner as an insolvent. Dissolution can also be done by the court. Let's say the partner has become of unsound mind, or they are incapable of performing their duties as a partner. They are guilty of a conduct which is likely to affect the carrying on of the business. They are committing the breach of agreements. All of these reasons can be on the filing of a suit by the partner for the dissolution of a firm. All right. Then, what will be the liability for the acts of partners done after the dissolution? So, any or all partners must give a public notice to the effect that the firm is now dissolved. This is because until and unless they give the notice, the partners continue to be liable to the third parties for any act which are done by them until they give such public notice. So, till the time they do not make the public notice, they will still be liable. So, the partners continue to be liable as such to the third parties or any for any act which are done by them, right? Which was done before the dissolution until the public notice is given. All right. So, this is there. Then, if we talk about registration, so we know that Companies Act, under the Companies Act, it is compulsorily required for a company to be incorporated and registered with the ROC, the Registrar of Companies, under the Companies Act of 1956 or the 2013. However, it is not compulsory for a partnership firm to get registered with the Registrar of Partnership Firms. It is not compulsory. The partners may or may not enter into a partnership deed and may decide to have an oral partnership if they have a strong understanding amongst themselves, right? So it is not compulsory. However, there are certain disabilities on the partnership firm that is not registered with the registrar of partnership firms, and this is given in the section 69 of the act. The section 69, a majority of the partnership firms, because of this, they decide to register to avoid any future hassles and complexities on solving the issues amongst the partners as well as the third parties. So, there are certain disabilities on a partnership firm that is not registered. All right. So, for example, the enforcement of any right to sue for the matters relating to the dissolution is not affected and it can be brought before the court of law. There are many effects of the non registration, like no suit or to enforce a right arising from the contract shall be instituted in any court if it is not registered. Unless the firm is registered, no suit can be filed. Again, no suit to enforce a right arising from a contract on behalf of a firm against any third party can be made unless the firm is registered. However, this will not apply to the partners or the firms which have no place of business in the territories to which the act extends, right? And we have already stated that the enforcement of any right to sue for the matters relating to the dissolution of the firm is not affected. For the accounts of the dissolved firm or any power or right to realize a property of a dissolved firm, it is not affected. They can be brought to the court of law. So, if we want to file a suit against a third party or any partner for the misconduct, that cannot be done if we are not registered. Other than that, regarding the dissolution, the suits can be filed. All right. So, that is all. These are all the necessary provisions under the Partnership Act, and this we have already stated. So, here's the information regarding the CAIIB Super Elite Plan. If you want to study all of these topics in detail, in depth, so that you can have the conceptual clarity, join us in the Super Elite Plan, which is the all-in-one plan. You will get here everything from live classes to mock tests and the downloadable class PDF notes, which are exam specific. So join the course now. Use the code CHAMP, which is the championship sales, which ends on 21st February. You can avail 50% off on your subscription. So enroll now, subscribe for the course, attend the classes, and start your preparation. If you have any doubts or queries, you can let me know in the comment section. Also, don't forget to subscribe to the channel because these videos on a daily basis are very important for your preparation. Thank you so much for attending. I will see you tomorrow with the next session. Thank you.